Hi, everybody, and welcome to today's webinar. I'm with Larry Donahue, a seasoned attorney here practicing in New Mexico, and he is going to be presenting today's webinar for us. I want to remind you to type all your questions into the Q&A. If you have any questions, please don't be shy. He picks them out throughout the entire webinar. I also want to remind you that the New Mexico Small Business Development Center strongly encourages New Mexico small businesses to be aware of the risks to their cybersecurity. We have a series of cybersecurity webinars available on our YouTube channel. I will chat over the link to you. Larry, I believe you give one of those series, so make sure you take advantage of it. With all that, I'm going to turn it over to Larry Donahue for They Owe You Money, Easy and Effective Debt Collection Strategies.
Thank you, Leslie, and hi, everyone. Thank you for joining us on this webinar. Before I begin, I just want to get a couple of administrative things out of the way. The first one is we have a bunch of links regarding COVID-19 business resources for you. It's the pandemic here is very confusing for a lot of businesses, and things are changing very quickly. So it's important that you stay up to date with those. If you want this presentation or get a copy of it so you can get access to all the links, all you need to do is contact the New Mexico SBDC and they'll give you a copy of the presentation. So there's no need for you to take notes or anything like that. Just get a copy and you'll have everything there. My name is Larry Donahue. I'm a lawyer. And before I begin, let me remind you, mute your audio, fit your Zoom ratio to fit window. And there's a Q&A function. Feel free to type in your questions there. And I like questions. So if you have them, ask them. Happy to do what I can to answer them on the fly. And if it looks like I've gone ahead and you're referencing another or a previous slide, if you can indicate what slide that was, that might be helpful. We're going to talk about debt collection strategies. And you really can't talk about debt collection without talking about risk, specifically financial risk to your business and how to minimize that. So we're going to talk about, risk mitigation, issues and options and steps. And we're going to talk about these and how they affect debt collection, what those issues are. And then, of course, we're going to give you some ideas on how to collect on debts owed. There'll be some objectives here, and one is to minimize those risks associated with unpaid debts. They cause businesses to fail, so we don't want that to be your business. So we'll talk about that. We need to make sure you understand the difference between consumer and business debt, and it's a little more complicated than you might think, of course. And then finally, how to improve your debt collection processes such that they are. Now, I got to give this disclaimer. I'm a lawyer, but I'm not your lawyer. New Mexico SBDC is not a law firm and cannot give legal advice. Therefore, you should really, view this material as general advice, not legal advice. And I've been a lawyer almost 30 years, and the words coming out of my mouth might be true for person X and false for person Y, because there's always a lot of nuance to these issues. And so you really want to get a good sense for them, and then really talk to a business lawyer you trust in your jurisdiction to make sure you are applying the right laws and systems and so on to your specific processes. With all of that, I guess, the big question is, I can summarize this presentation in one slide. That's not going to help you, but what would that summarize or summarization be? Well, it would be telling you what the best debt collection strategies are by far. The first one is not to have any debts that need collecting, right? What does that mean? Well, we'll talk about that in a minute. Or hiring an attorney or law firm, right? Just go and pay the money and have them chase down your debts for you. Those are the best collection strategies. However, that's probably not really the best and appropriate way for most businesses. So the real question we have to ask is, how do you avoid debt collections in the first place, right? And if you think about it, the best strategies are those strategies that put in place the easiest way to handle it. Or another way of saying that is avoiding the problem in the first place, right? How do you avoid that? And one of the ways a business can do that is to get paid before or during the provision or fulfillment of products or services, right? So you see this a lot on the internet. You know, you'll pay for something and then Amazon will ship you something. But they have debt collection issues too, and we'll explain why. Another way to avoid debt collection is to not let anyone owe you any money. But that really isn't possible in most circumstances, right? Or many circumstances. What would be one example? Well, refused or refuted funds. So everybody probably, if you received checks, you probably have had a bounced check or an NSF, not sufficient funds return on a check, chargebacks. So even Amazon, right? You pay in advance and then they'll ship you the product. You know, there are chargebacks and accusations of fraud, and they have a big department to deal with all of that. And certainly you would as well. But there's other ways or issues associated with avoiding debt collections, and that's just customary practice. You know, most restaurants, hotels, motels, you know, that the customary practice is to provide the service first and then get paid for it afterwards. A lot of repair services are this way too. You know, HVAC, autos, trucks, bicycles, you know, grooming, dog grooming, you know, so there's a laundromats. So there's a lot of customary practices where you do the service first and then you expect to get paid for it afterwards. And then finally, competitive forces, you know, and we see this sometimes with like bigger projects, RFPs, contracting type stuff, general contractors or subs, you know, electrical contractors and so on, where a customer or client is shopping for more favorable payment terms, whatever that means, depending on the type of project. The trick associated with all of this to avoid debt collections, and it should be your primary objective as a business, is to reduce the risk associated with not getting paid. So I want to spend time discussing that, because by doing that, you're going to need to rely on your debt collection strategies less. And when you do need the debt collection strategies, it will simplify the effort of eventually getting paid. And you may be thinking, why is that important? Well, it reduces the deadbeats, or those who may not have the means to pay you. It reduces the time it will take for the debt collections to actually work and for money to get into your bank account. That means it will reduce the effort associated with debt recovery. It'll reduce the time to get paid. It'll reduce the costs associated with debt recovery. So in other words, reducing risk increases potentially significantly the cash flow to your business. It will improve the financials, and it increases the value of your business. So on top of all the other things you have to worry about as a business, right? Meeting payroll, finding clients and customers, and marketing and sales, and then fulfilling the product or service that you produce, you got to worry about this. And what I find often is it's usually the secondary thing. Most people will work on the sales and getting customers and so on, and then start worrying about these other processes. Sometimes people just won't worry about this at all until it gets to be a real problem. And then they're hiring me, the lawyer. And guess what? I say this all the time. If you hear me say it makes my job easier, think a lot less expensive. And conversely, if it's hard for me to do the job, think a lot more expensive. So the point is, you want to set things up and reevaluate your processes relating to customer acquisition and payments so that you are minimizing this risk, and that's going to greatly improve your cash flow. and it may save your business. And heaven forbid, if you ever need to hire somebody like me, you're going to reduce the costs and expenses associated with me, which could be really important. It could save your butt depending on how much is owed. So let's talk about how to reduce risk. And we're going to spend a lot of time discussing that. And then we're going to move on to how that affects your debt collection strategies. But there's a couple of points here I want to bring up on reducing risk. And the one is to know your customer. And each business type and model it's going to vary drastically. You know, if you're selling snow cones as a street vendor, you probably don't care so much about your customer unless maybe you're serving stuff that has allergies. So you need to know your customer doesn't have allergies at the very least before they consume your product. But you have stuff on the very other side of the fence where, you know, maybe an MBD business where you really need to know the customer and you need to make sure you're issuing the right product or license to the right person. So, you know, but in most businesses, you should really know your customer, and we're going to explain why and how to know them better. You should also maximize the security of the payment. And what do I mean by that? Well, if I promise you payments in a hug and a kiss, that's really not very secure. What the hell is that? And how do you use it? Versus if I'm going to give you cash. And as you know, there's a lot of other payment options here, right? You know, credit cards, cryptocurrency, promissory notes, so extending credit. So all of those carry different types of risk, and it's important to maximize the security of whatever payment is being paid to you. And I'll explain more here in a few minutes. The other thing is where and when appropriate to collateralize debts if possible. And I'll explain what collateralization means, but it basically, you know, if you have a mortgage, that's a collateralized loan. You borrowed money from the bank to purchase a house or other piece of real estate, and the mortgage basically is a security against you not paying the debts or obligations back to the bank or finance company. So they could potentially foreclose on a home or other piece of property. Where appropriate, you want to define SMART goals. And this is, again, not really appropriate or necessary for folks selling products or certain types of services, but it's really appropriate for consulting-based businesses, contractors, people that are building, have a sort of project-based work or products or offerings. Strong and appropriate contracts, where and when possible. Again, the snow cone street vendor, not going to have contracts at all. But you might have a little statement on the front of the window. It says, if you have a peanut allergy, don't buy here, or don't buy this particular product. That is a form of a contract. And that is basically saying, you have a potential issue associated with allergies, and you need to make sure that it's visible and available, and that would potentially protect your business if somebody got sick because of a peanut allergy, for example. So let's talk about knowing your customer first. And you really need to determine two things about each customer you have at a high level. And of course, this varies drastically depending on the type of business you have. But in general, you want to make sure the customer is who they say they are. And you also want to make sure that the customer has the financial means to pay. So if you have somebody walking off the street trying to buy $1 million of light bulbs or construction equipment from your business, you better make sure that they can afford to pay that. And so how do you do that? Well, one is you should always ask for ID when accepting any form of payment other than cash. If you're getting cash, cash is king, I think. But other forms of payment, especially credit card, checks, you want to verify the ID and the individual, a photo ID. So you have their picture, you have their name, and the name matches the credit card or the check. And the reason you need to do that is if you don't, then the person's name on the credit card or check can refute the payment and say that that was fraudulent or done without their authorization, and there's not a heck of a lot you can do about it. You have to go after the guy or gal who gave you the bad credit card or check. And do you even know who they are? Because did you ask for their ID? So that's why it's important to get the ID. And if that's not going to happen, what I mean by that is if the name on the card doesn't match the person presenting it or the check, you need some sort of authorization that the person who is paying is willing to be financially responsible for the transaction. So as a lawyer, we make clients fill out an engagement agreement and a credit card authorization. But we will have instances where the business owner's brother, who also happens to own the business, is sending, the credit card is in the brother's name, even though our client isn't using his own credit card. He's using his brother's credit card, but both people own the business. And in that circumstance, we would make the brother sign a third-party authorization to pay legal services. Because guess what? We've had this situation where the brother refutes, they issue a chargeback saying, I didn't authorize this. And guess what? The chargeback wins. Do I have a case against our original client? Yes. Got to go chase him down and hopefully he has money. And now I'm in the debt collection world. So it would be easier and better to have my client's credit card. And if not, I want to have authorization from the other paying party. And this happens a lot. You're going to see this even in restaurants and, the husband borrows the wife's credit card and vice versa. And guess what? If you have a credit card in the wife's name and the husband signs on it, can you have a cause of action against the husband to pay? Sure, of course. You provided a product or service to the husband, but you're going to lose the chargeback. So being able to win a chargeback is a really easy debt collection strategy. And if you're going to lose the chargeback, you've just moved yourself into a much harder debt collection strategy. When you hear harder, what do you think? More expensive. So that's why you need IDs, and you may need to make it part of your business strategy. Now, depending on, if you're selling, if you're a restaurant and your average bill is, $30 to $100, you don't need to make copies of the ID. But if you, for instance, are using, let's say legal services and your average bill is in the thousands, it might be appropriate to make a copy of the ID and put it in the file somewhere. Securely, of course, because you need to protect yourself against getting hacked and private, personally identifying information getting released to the public. If you're taking a credit card up front, authorize it. So just by the fact of having the credit card itself, I see this in bars, they'll take my credit card and just put it up on the, bench somewhere. That doesn't mean the credit card is mine. It doesn't mean there's enough funds on the credit card or that the credit card is even authorized. So you want to run it. And what my firm does is we make a small charge. We charge $3.95 plus gross receipts tax. And we just basically call it a small sign-up fee to protect our clients, because we will not hold the credit card information. We'll run that initial charge, and then our system creates what's called a token, and then it uses that token to do future charges to that credit card. So we don't need to have the credit card on file. We need to have a credit card authorization. So if they do a chargeback, we can say, hey, nice try. You agreed to let us use the credit card. But we authorize that credit card. We make sure that it works, and you should do that too. There are, depending on the point of sale system you have, you should have the ability to at least authorize the credit card. And you'll see that happen like if you go get gas and you use a credit card. What do you think's happening when you put your credit card into the machine? It's actually authorizing and verifying that the credit card is available for funding. And you should think about that for your business as well, if that is available and appropriate. Do you extend a credit line? Do you allow people to, depending on who the customer is, do you give them some sort of credit, in-store credit, line of credit, or otherwise? If so, ask yourself, how would a bank do this? And I bet you would think, perform a credit check, establish payment terms, make the customer sign a promissory note. Never, ever, ever extend a line of credit based on a handshake. Now, can you extend a line of credit on a handshake? Sure, but you're making my job harder. And again, when you hear the lawyer say harder, think a lot more expensive. So you want to pretend, you aren't a bank. And if you are a bank, you have a lot of sophisticated issues. You probably know a lot of this already. But most businesses aren't banks, and don't treat yourself as a bank. And if you're going to do that, then make sure you do it correctly and put the right pieces in place, including the credit check. Are you going to be doing business with a company versus an individual? If so, there's some things you need to know. One is, does the company exist and is it in good standing? If you are doing business with a New Mexico company, or at least that's what you're told, go to the New Mexico Secretary of State and look up the company. Make sure you have the actual legal name, because you'd be shocked how many business owners don't even know the real name of their company. It's outrageous, but it's true. So you need to make sure you have the real name of the company. You need to make sure you know where it's registered, New Mexico, Delaware, Wyoming, wherever, and you need to make sure it exists and is in good standing. Otherwise, who do you go after? We want to know who that is. You also, depending on the nature of the debts or obligations, you want to consider having the owner sign a personal guarantee if appropriate. You're going to see that a lot with commercial leases, for instance, where the landlord is forming a tenancy relationship with a company, but they're still going to make the owner or owners sign a personal guarantee. And then finally, there's a thing called Dun and Bradstreet, if you don't know about it, the D&B. You can do a credit check with companies. Are they paying their bills and debts and obligations or not? And don't be afraid to do a credit check on the owner or owners who are going to sign a personal guarantee, because the personal guarantee is only worth what the owners are. And if they're destitute or not paying their bills, they can declare bankruptcy even. You want to make sure they're not doing those kinds of things and that they're a good credit risk. And if not, you need to evaluate that and maybe not give them so much of the line of credit, or you reduce the terms. And I see my picture is frozen. Am I still on, Leslie?
Yes, you still are.
Okay, so I didn't, okay, it looked like it got interrupted for a second, but we're okay?
Yes, we're okay right now.
Thank you. Sorry about that, everyone.
That's okay.
So let's talk next about maximizing the security of the payment. And I mentioned this before, but cash is king. When you're holding cash in your hand, that is so much more valuable just about any other form of payment, right? Even credit cards, good credit cards, still take a few days to clear and show up in your bank. Also, credit cards have what's called contingent liability. What that means is the customer can issue a chargeback for up to 6 months on whatever it is you've sold them. So a credit card is still risky. And finally, of course, there's the fees associated with credit card processing. And usually they're going to be anywhere from like 2 to up to 5% or so. And I want to warn you about credit cards, because when you're looking for a merchant account provider, they're going to quote you really low rates. And what you need to think about when they quote a low rate is that it's only for card present swipe transactions without any corporate surplusage and other charges associated with that. So even if you had a corporate card and you swiped it, you're still going to pay more than the minimum rate associated with like cash back and stuff like that. You, the merchant, actually pay the cash back, not the credit card company. So it's a huge problem that a lot of businesses don't fully understand. So credit cards are far inferior to cash. But cryptocurrency is also valuable because you get paid immediately. There's a small transaction fee that the customer pays, not you. And then finally, it's instantaneous and it can't be chargeback. So it's very similar to cash. More of an accounting headache, but it's still valuable. And if you can utilize that in some of your business processes, that may help reduce debt collection problems. But credit cards are there, right? They're the big 800-pound gorilla, and consumers are going to demand them. And frankly, for us businesses, I prefer paying credit card if I can over cash. Why? Because I get the points, you pay for them, it doesn't affect me. So then I get to travel on them and so on. And then also, if the relationship breaks down, I can do a chargeback. So it's beneficial for me as a business to use a credit card, and I want to use that. But they require special handle. And there's a few things I want you to do when you're accepting credit cards. One is, and I told you this already, you need to verify the name on the card with who's presenting it. You know, if it's the husband using the wife's credit card, where's the wife? Make sure the wife is around. And if the wife isn't around, get some sort of documentation. You know, authorize the card if you're not going to get paid first, but you have access to it. So if you're delivering products or services before getting paid, find out how you're getting paid. If it's by credit card, ask for it. Authorize it. Make sure it's valid and it works and it has the credit limit on it that you need. As I mentioned on the cash side, swipe transactions are best. Now, why are they best? Well, I hinted at it earlier, right? When I said the fees that you pay for credit cards are lowest with card present swipe-based transactions. So that's number one reason. It's the cheapest form of credit card usage is by the swipe. But however, they're also easiest to fight chargebacks with because the card was there. So you could show that you had the card. However, if you're not validating the person, you could have whoever's card it actually was say, that wasn't me. I didn't authorize this. My card was stolen. And then you're going to lose the chargeback fight. So that's why you want swipe transactions if you can. And I can't tell you how many businesses I've been in where they actually have the card, but they're typing it in. They're not doing a swipe. The moment you type it in, it's not a swipe. It is called a mid-qualification or mid-qual transaction. You are paying higher rates. It's not a swipe. It's a card, not present transaction, and it's harder to dispute if there's a chargeback. So if you have the card, figure out how to swipe it. And if your merchant account provider did not give you the right tools to do a swipe, contact them and get the right equipment so you can do the swipe. It'll save you money and it'll help you with chargebacks. Now, with all of that said, it could still be disputed, right? Because as I mentioned, they could claim the product wasn't delivered. The name is different from the person utilizing it. They could say they weren't there. You need to think about ways you can disprove that, whether you have cameras or what have you. But a driver's license has a signature on it. Verify the signature. And if it's not similar or the same, don't accept it. You need another form of payment. So, finally, regarding credit cards, make them sign an authorization or promise to pay. So you'll see this at doctor's offices sometimes. If you bought, me, Larry the lawyer, I don't sign anything without reviewing it. And it just upsets me to no end when I'm at the doctor's office and the business office, and they start explaining what it is I'm signing. And I'm just like, please shut the hell up, because whatever words come into your mouth doesn't matter. What matters is what's in the actual document I'm signing. But in the doctor's office, they say, you promise to pay even if the insurance company doesn't pay us. You promise to pay even if your credit card declines or insufficient funds. So basically, you're signing away your right to fight or dispute payment. Or if you're saying, oh, well, I expect insurance to pay this, well, the doctor still gets paid even if insurance doesn't pay. So that's the kind of authorization you should think about in your business. And it doesn't have to be big. It can be part of the credit card slip, or the sign-in process or whatever you have. But having something like that is very helpful in disputing chargebacks. Also, I need to remind everybody, checks are always a risk. You should consider calling the bank and the actual bank listed on the check. You can give them the account number, the routing number, and verify funds available. Especially for larger checks, you should certainly do that. Even cashier's checks can be fraudulent. They are not equivalent to cash. And that it's a big problem with a lot of businesses, by the way, with fraudulent cashier's checks. So typically, when you get a cashier's check, there's this expectation on the customer side to turn things around quickly. Hey, I've given you cash. No, you've given a cashier's check. And you have to call the bank and verify that it's valid and the funds are available, number one. But even then, you can submit the cashier's check. And then this is what's really troubling is if the other party says there was something fraudulent with the transaction, they can get the funds stopped or pulled back within some period of time. What is that period of time? It depends on the policies of the bank. So it's always been more than 3 days. I've seen on average 10 days. I've seen it go up as high as 15 days. So when somebody gives us a cashier's check, our answer is we're happy to take the cashier's check, but we are not going to honor those funds until not only do they clear, but they settle. And we'll usually give, 2 weeks or 14 business days for that to happen. So it depends on the money and the amounts, but you want to be careful about all. And then finally, of course, verify the presenter's ID. Make a copy. Write the ID number down on the instrument. You can do that on the memo field, for example. You could do that on the back of the instrument. So tie the ID to that instrument, and it helps your business processes. It doesn't necessarily create proof of the individual making payment, but it can help us identify who wrote that check and hold somebody accountable if they're trying to actually commit a fraud of some sort. So let's talk about collateralized debts for a moment. So I talked about this a little bit, right? On the real estate side, if you have a mortgage, that is an example of a collateralized debt. It basically says, hey, I have the right to take this asset if the loan agreement or other security agreement we have is breached for some reason. So it allows me to potentially recover my money that is owed to me. And what you have available to you is going to depend greatly on the nature of your business and what you do. Again, with my example of the snow cone vendor on the street, you're not going to care about this at all. But if you are a contractor, for instance, or a landscaper, if you're improving land or real estate, you do get what's called a mechanics lien for the work you do. But you need to know the rules associated with them and how to, quote unquote, perfect them. They are limited in time, they're limited in scope, they're limited if you don't perfect them. And then when you do perfect them, it's only for a certain amount of time. And what I mean by perfect is to register, submit some sort of statement. It's usually in the form of a lien submitted to the county relating to the specific property. So you're going to need to know the legal description. You're going to have to present the exact amount in the invoice. You have to back up what that is. And then you have a statutory lien on a piece of property. What does that mean? Well, it means they're not going to be able to sell it. They're not going to be able to possibly get a new line of financing. Banks won't do that because they always want to be number one in priority. Your lien, mechanics lien, will come in after whatever else is there. So if there's a previous mortgage, you're not going to take over that previous mortgage. But if they wanted to refinance, that previous mortgage gets paid, you then come up to the top and you're not going to get a mortgage company wanting to be second at the trial. They want to be number one. So they're going to want this piece to go away. So what if you have a customer who has a piece of land that they're not intending to sell for 100 years and they own it outright? Well, then the lien isn't going to help you a whole heck of a lot. The other issue is, in New Mexico at least, it only lasts 2 years without some sort of judicial intervention. So it's not a long-term viable strategy or solution. So you need to know what the contours of the law are and then make sure you operate within it, because once you finish the job, you have a certain amount of time to do it. And it's going to depend on whether you're the primary or you're a sub. There's some rules around all of that that you really need to look up and understand for your type of business. Are you delivering expensive products? If so, then you want to make sure the customer signs a promissory note and a security interest agreement. The security interest agreement is basically an authorization by the customer to permit you to file a lien on something. And the lien is what's called a UCC1 statement. So you can then, that's called perfecting. And instead of sending it to the county, you send it to the Secretary of State's office. And most states do that, but if you're in a different state than New Mexico or Illinois, where I'm licensed, you should look up the right process. Now, there are some exceptions to this, and remember what I said about priority. So it's important to understand the pecking order a bit and who you're doing business with in order to do this correctly. And that's why I'd advise you to seek competent legal advice in how you put a process like this together when you do fulfillment. But expensive services. Let's say you are remodeling, or you are, I don't know, doing something with livestock. Treat it the same as a product. So the difference, though, is you would got to ask yourself, what can you attach? And what could be the subject of the security interest agreement? And if you're providing an expensive service to a business, that could be inventory. It could be accounts receivable. So what is accounts receivable? It's any cash or money that is due the business, or the business earns or receives. You could form a security interest on that. But you got to be careful, because if they have lines of credit, financing from other institutions, those other institutions are probably already going to have the same thing, and they're going to take priority over you. Another way to deal with this is to get payment up front, of course, for an expensive service, and or establish payment milestones with payment tiers. So I see people doing very difficult or expensive construction projects, for instance, and I have client A that takes no money up front at all, and then just wants to get paid at the end of the job. And it's like, well, when does the job end? Is it when the client or customer says, I'm 100% satisfied? Or is the client or customer going to keep stringing you along and wanting you to redo things because they don't like the way things look, or they think the quality isn't there? So it helps to establish payment tiers in place. But I want to warn you when we talk about collateralization. Just because you have a security interest doesn't mean you can just walk in and seize the asset. You have to foreclose on it in New Mexico. So that basically, seeking some sort of, judicial response. And then usually it's not you going in and seizing the collateral, but it's, handing some sort of writ to a sheriff, and the sheriff goes and seizes the collateral. The reason they do that is to limit opportunities for violence. But it does depend. Different types of collateral are different in different circumstances. And one example would be a landlord with a tenant. You can put, landlords have the ability to seize personal assets and lock the doors in certain circumstances if it's in the lease. So you really got to double check this for your specific business. One thing I want you to know about is what's called a purchase money security interest. This is a statute in New Mexico. And if you're selling products to consumers or to others, it could be businesses too, you get an automatic security interest in what it is you sell. But you need to perfect it. And perfection is submitting a form to the state. But there are some issues with this. You don't need to get a security interest agreement. So if you were, let's say, a car stereo store and you sell a stereo, you have an automatic security interest in that car stereo. If you have a retail business and you're selling to consumers, it's automatic. You don't need to file anything with the state or the UCC. But if you are providing inventory for another business, this is more complicated. So let's say you're a supplier for other businesses. That's potentially inventory. That you need to file a UCC1 for, a UCC1 with the Secretary of State before they take possession. Also, you should do a search and see if there is a pre-existing security interest claiming inventory, such as a bank with that provided a line of credit with that business. And if so, you should notify that business. Now, when you do that, you then get priority for that inventory over the bank. But if you don't do that, and there's a bank that has a UCC1 for inventory, accounts receivable, fixtures, and so on, the bank takes priority over your stuff. So if, and we've had this where, you know, the business that sold some inventory to another business goes and reclaims it, was even given it back by their customer. Then the bank swoops in and says, you can't do that. We have a priority over that, because the moment you transferred the inventory to the business, the customer, our UCC1, our lien then has precedence over you and your stuff. Give that back, please. So if you have expensive inventory or a lot of money at stake, you really need to understand and know what this is, and you need to deal with it appropriately in your fulfillment and purchase processes. It's really important to understand it. And as you might imagine, you know, I'm dealing with like brick manufacturers supplying bricks to contractors, and that the dollar amounts at stake here can turn into some really big dollars, and you may lose those dollars and have a very difficult time collecting if you can't maintain that collateral. So that's something to be aware of. It is a very complicated area of the law, and you really need to make sure you talk to a lawyer or somebody that knows this area so they can map it to the contours and issues of your business. Finally, not finally, one more thing, SMART goals. SMART goals, basically, it's an acronym for specific, measurable, attainable, realistic, time-bound goals. And what this means is you're defining something with enough specificity so that somebody can't use it or hold it against you. If you are providing services, you want to avoid scope creep, whether you're a consultant, a web developer, anybody else, you want to make sure that you can define what it is you're doing specifically so that you can make sure you get paid on time and that the other side can't say you didn't deliver. And we have a question here. John asks, what is the maximum interest rate that can be charged on outstanding receivables? And, you know, John, I apologize. I'm loath to give you an answer off the top of my head for several reasons. One is it's going to vary by state by state. Two, it's going to vary depending on what we are talking about in terms of the nature of the loan. Is it a business to consumer, business to business? Is it short term? All of that is going to affect the potential answer. So I really can't give that, and I apologize. What I will say is, at least in New Mexico, if it's business to business long term, there isn't a usury limit or rate, but that could be very wrong very quickly depending on the circumstances. So you really need to double check that. And then you should have in your agreement a statement that says something to the effect of the interest rate charged or the annual percentage rate, whatever language you want to use, is going to be X, or is outlined in the proposal or work order, or to the maximum permitted by law, whichever is more. So you kind of give yourself an escape if you are wrong or the law changes on you, and the statutes will do that. They'll change the rate and they'll make them effective upon passing or signature of the law for existing contracts. So you don't want to get yourself into that situation. But that's an excellent question. I'm sorry I can't be more specific for you. Let's go on with appropriate. I want to give you an example of SMART goals here quickly. Are you a landscaper? Don't agree to this. Make your backyard look great for $10,000, right? There's so many problems with this. What would be better is to say something along the lines of, we're going to replace these specific plants. We're going to put a weed barrier up in this area with this many square feet. We're going to put a fill-in of crusher fine, 1/2 inch deep. We're going to put a fill-in of pine, not cedar, wood chips. People argue about this stuff all the time. And if they can argue something, it makes debt collection a lot harder. We'll replace bare spots in the lawn, but you got to water them. Otherwise, you still got to pay us. We're not going to warrant that. When does the project start? Do we need unimpeded access to the yard? We need to know whether you're going to do this project within 3 days, a week, a month. And then when you do let us know, we're going to be able to finish within a certain period of time, but only after you give us go ahead. You got to put bounds in place. You don't want a client calling you up 2 weeks, 2 months, 2 years later saying, okay, I'm ready to go. And now you don't have a team available because they're out doing other stuff. So you want to protect yourself that way. And then finally, don't forget about payment. What do you need to start the work? What do you need when certain milestones are completed? And then, do you get the rest upon completion? Let's talk about strong and appropriate contracts quickly. Not all businesses are going to need them. The example I keep using with the snow cone vendor on the street, of course, but a lot of other businesses would be helped with contracts. And there's really two components to a contract. There are the business issues. How much? What are you doing? When? Are there any customer duties? That's where SMART goals kind of come in. Do you generate a proposal or a work order, a cost estimate? What do you call it in your business that you sort of fill out? The customer says, okay, I want to get this done. What is that? That's business type stuff. The contract is legal type stuff. It incorporates all the business issues you've agreed to. So if you generate a proposal, you're going to tell me how much and when you're going to do it and what the scope of the project is. Well, then the contract should incorporate that proposal. And what does that mean? Well, you have a really nice, sexy looking document that sells me on your product or service. I don't want to see any legal mumbo jumbo. If you're going to put legal mumbo jumbo in front of me before I make a buy decision, I'm probably going to not buy it because I don't want to read through the legal mumbo jumbo. And most people feel that way. So get rid of the legal mumbo jumbo, sell the product or service with something sexy, a work order. Once they say yes, now the contract comes and it's a formality. It's not an issue of do I want to do this or not. It's just simply, okay, well, let me look at the contract, and most people don't even look at it. But we're going to refer to that proposal. We're going to address dispute resolution, debt collection, and other relevant or important issues for your business. And some critical clauses that should be in every contract. And when I say this, you probably know this, but understand a lot of our clients don't have it in their contracts. And then it makes my job for debt collection harder. And when a lawyer says harder, what does it mean? More expensive. So you want attorney's fees and court costs. And I'm not saying that just to be self-serving here to get paid. It keeps people honest. If they know that they have to pay your legal fees, if you got to go to court and sue them to get paid, they're probably going to just say, screw it, let me pay them and be done with this, because they don't want to pay your legal fees. So it helps keep people honest, be honest. If there's no attorney's fees clauses in the contract, you don't get them automatically in New Mexico and most states. Texas, you do. but not in most other states. And what that means is every dollar you throw at me, you're kind of wasting it unless you have an attorney's fees clause. So that will limit when you can hire a lawyer if you have smaller debt issues. And if you have bigger debt issues, if you have another party not acting in good faith, they know they're just going to rake up the legal debt with fighting with you. And so they might be willing to do that, especially if they have a lawyer in the family or on staff, for example. Jurisdiction is important. You know, if somebody's going to go to court, shouldn't it be in your backyard versus theirs? It just is more convenient for you. But other important clauses, indemnity, limited liability, limitation of warranties, those are really important clauses depending on the type of business you have. And then, you know, finally, a dispute resolution process. You know, if somebody wants to dispute or not pay you, what kind of process do they need to follow? You know, do they need to issue you notice? Do they got to spell it out clearly? And if they don't do that, or if they don't do it within a certain period of time, then they lose the ability to dispute, for example. Those are really great clauses to make my job easier in debt collection. Finally, a couple of other things I want you to be aware of when thinking about an appropriate contract. And that is, especially on the payment terms and lines of credit. You need a promissory note, payment terms, amounts, interest rates. You need a security interest agreement if there's an ability to collateralize something. And then you need permission to conduct a credit check or periodic credit checks if this is an ongoing line of credit issue. You want to be clear of any knowledge around installment agreements and usury statutes in your jurisdiction and with what it is you're doing. And you need to make sure that you comply with those. And then also give yourself an escape clause, like I mentioned earlier, meaning the interest rate is going to be, I'm making up a number, 12%, or the largest amount permitted under statute, whatever is greater, something along those lines, so that if the usury amount changes over time, your contract doesn't become null and void all of a sudden. If your customer is a company, remember what I told you earlier. Where is it registered? Verify it exists and is in good standing. Make the owner sign a personal guarantee. But remember, the personal guarantee is only good as the credit worthiness of the owner in the first place. Conduct a D&D check on the company. So I just went through and I spent 50 minutes on reducing risk. And the reason I did that is all of those pieces are really critical and important to reducing the costs associated with potential debt collection, as well as reducing the necessity of debt collection. So if you rethink your processes and think through those things, it will reduce the need to do debt collection. And then when you do need to do that, it'll be easier and faster and less expensive. But let's assume we've done all of that and you're still owed money. So now what? Well, you have some options. You know, what strategies, what options are available to you? And the first one is you contact the customer and attempt to collect yourself. There's nothing preventing you from doing that. And you certainly should do that and have that in your business's processes before you escalate further. And, you know, I recommend some gruff employee who doesn't care whether somebody says get lost and doesn't care if they get hung up on and doesn't get depressed or emotionally drained when that happens. Me, that can happen to me. So I don't like doing that. But I have a member of my staff, I think they get the wind under their sails with that for some reason. So that's the person making the debt collection calls. But you can also, of course, hire an attorney or law firm or debt collector. I would recommend that actually in certain circumstances, and potentially consumer debt in certain circumstances, which will make sense in a minute. But you can also foreclose on any collateral. And then once you get the collateral, it's yours. Go sell it, do what you want with it to try and, you know, get the debt satisfied. If the debt's under $10,000, and it depends on the jurisdiction you're in. If you're not in New Mexico, it may be a different amount depending on the county you're in. But find out. It's generally going to be a small claims court. New Mexico, it's a Metro District Court. What matters is the county where the customer is located, not where you are. unless you have a contract that specifies jurisdiction. Then it can be in the jurisdiction that's specified in the contract. But you can file the lawsuit yourself. Most of these small claims courts are going to have online forms that you can download and fill out and submit a complaint yourself. Now, some of them are going to have rules. If you have an LLC or corporation, they may want you to be represented by counsel. In New Mexico, that's the rule. Companies have to be represented by attorneys, but people will go and submit the lawsuits anyway without an attorney, and sometimes the courts allow it. So try it out and see what happens. Let the customer explain to the court why they don't need to pay you or not need to pay you the debt that is owed to you. That might be a great way to save some money and do things yourself. But those are the main strategies, but you need to understand some ground rules before you do that. The first one is the Fair Debt Collection Practices Act, FDCPA. It's a really important one, but it doesn't apply with business debt, corporate entities. Be careful with sole proprietorships. This is why you want to know the customer. Are they a business? Are they an individual? If they're a sole proprietorship, can you prove it's a business debt versus a consumer debt? If you can't do that, then you might have to be more careful about the FDCPA. So it's not it seems like a bright line rule, but it could be easily, you could easily step over the line if you're not careful with sole proprietorships. But it mostly applies to third-party debts. So what that means is it's not the debt you're owed, it's you give that, you hire somebody else to go find it, like an attorney or a debt collector. So if you are going after the funds yourself, it's fine, but you need to be careful. There's this line in the statute. Basically, it says, if you're using a different name than which is used for that debt, then the FDCPA applies. So I'm not going to go into what the issues of the FDCPA require. That's a whole nother discussion. The big issue for you is, does it apply at all? And if it doesn't, then fair game. If it does apply, then you need to be careful, because there are a lot of requirements about what you can and can't do. And then if the client tells you to go get lost, you got to go get lost. There's a lot of issues there you're going to need to know about. But if you are dealing with a business, it's fair game. But it's going to be, your ability to collect will be addressed by the issues I raised around risk earlier. So it's also going to be addressed by the contract that may exist, including the dispute resolution process. So make sure you have a contract and you have it available and you read it and you follow the dispute resolution processes, including notice requirements. So you want to follow those, and if you do, then we have some. And if you don't follow those, now you're in breach of your contract. Now you've just given an excuse to potentially not pay for that service or the debt. If you're dealing with a consumer, you have to be cautious. Specifically, you got the FDCPA issues that I raised. My suggestion would be maybe hire a professional, at least to identify what those FDCPA rules are and then operate within them. And that's it. We have a couple minutes left. I don't know if we're going to have any questions, but I appreciate your time and thank you for joining us.
We don't have any questions coming in. And Larry, of course, I want to thank you as always for giving us such relevant information. I want to remind you that we have webinars available at no cost on our website at nmsbdc.org. And also want to remind you that the Small Business Development Center is here every step of your business to help you at any phase that you're at. So you guys have a great rest of your week. Larry, do you have any wrap-up information before I pop everyone off?
No, I think that's it. I can put more people to sleep on FDCPA requirements, but I think that'd be another seminar entirely. But thank you.
Absolutely. Thanks, Larry. You guys have a great rest of your week. Bye.